Hello, good morning. Thank you for joining us today. I'm Vivian Cristino, Capacity Building Specialist at Housing Action Illinois. This presentation is being recorded and will be available for download in our website later on today. Also, I will send you by email the link with the PowerPoint slides. You have a handout in your panel, in your control panel, so please download those as well. The flyer of LAF ADAPT program that is available and encouraged for clients in Cook County. Also is a list of terms and definitions that Katie is going to use in this webinar. So thank you for participating in the webinar entitled Dealing with Property of Elderly and Deceased Mortgagors. During the webinar, you will learn about tools to plan for death and incapacity of a mortgagor, including powers of attorney and transfer on death instruments. The process by which property passes as death, we will cover joint tenancy versus tenancy in common, wills, in-state succession, and the probate process. Options and strategies for heirs to work with mortgage services to try to assume and modify the mortgage loans, including the rights under Garn St. Germain. Our presenter today is Katie Lees, a senior attorney at LAF Consumer Practice Group, where she has worked since 2012. Katie works in the Consumer Practice Group, focuses on preserving homes and other assets through bankruptcy, foreclosure defense, and affirmative litigation. Katie is a 2008 graduate from the Loyola University Chicago School of Law. Thank you again for participating in the webinar. If you have any questions, please write in the window your question, and we'll be sure our panelists answer it during the presentation. Okay, Katie?
Hi, yes, thank you for having me. So my presentation today is kind of divided into three parts. First, I'm going to talk about what senior homeowners can do to plan for their own death or incapacity. And then second, I'm going to talk about the ways that property transfer at death, because I think that that's important to understanding the rights that heirs have and how to help heirs of homeowners. And then lastly, I'll talk about strategies for helping heirs to assume mortgage loans or to otherwise keep their homes. I'll try to touch also on heirs of reverse mortgage borrowers in that. So if you have any questions, feel free to write them in through the webinar functions. I'll do my best to answer them, and I'll also try to take some time at the end for questions. Okay, so planning for death or incapacity. There are two different documents that I would really recommend senior homeowners, I mean, maybe not even advanced seniors, but anyone over 60, maybe even over 55, should start thinking about, just to make things easier down the line for as they get older, as they lose capacity or pass away, to plan for how their property is going to pass. I think the most straightforward thing that they could do is called a TODI. It's a transfer on death instrument, and these were new in Illinois, I think about 5 years ago or so. Not every state has them, so Illinois is fortunate that this is an option. But what it is a simple document similar to a deed that the homeowner can execute, and it basically just says, the homeowner designate that, upon the event of my death, this is how property is going to pass. This is the person or people that I want to take ownership of the property, and they can even designate, how they should take ownership of the property. And then the document does need to be, executed before a notary first, and then also recorded with the recorder of deeds. The fees, at least in Cook County, recently increased for that, so it's almost $100 to record this document, but I think it's well worth it. It can save the need for probate and everything down the line. And again, the great thing about this is that the property doesn't transfer at the time; it just transfers upon their death. I mean, another option is also, I'm sure you're aware of putting the property in trust, where the homeowner would transfer the property into a trust, and then it's held in a trust that says, at the event of this person's death, it transfers to this other person. That's also an option, but then you need to pay, the trustees' fees. You need to transfer the property to the trust while you're living and everything. Here, the property stays, under the name of the homeowner until their death, and this document just signifies that at the event of their death is when the title is going to pass to the other person, whoever the homeowner designates. The other document that we would really recommend, senior homeowners, anyone over 55 would maybe consider, is having a power of attorney for finance. And under this document, you might already be familiar, but the principal, the individual, can designate one person or even a secondary person, or more than one person if they really choose, to act on their behalf for financial transactions. They can designate, a son or a daughter or even just a friend, whoever they trust, to do things like sell their property, do bank transactions, apply for property tax exemptions or any other, tax matters, defend or bring claims or litigation, which would include defending a foreclosure, even borrowing transactions. They could even, potentially take out a mortgage or a reverse mortgage if they had to. This allows, someone, while they're still young enough that they're of sound minds, to choose the person that they really trust to be able to do these things. There's a few different ways that you can set up the power of attorney for finance. You could set it up so that it goes into effect right away, which, if you have a more elderly homeowner, it might be what they want to do. Maybe they're just kind of, tired of dealing with their own financial matters. They know that they're starting to decline, that they want their son or daughter to just start acting on their behalf. You could draft this document. This document can be drafted to go into effect immediately. But what's probably more common is that it can also be drafted so that it doesn't take effect until the person loses capacity. So they can say, I want my son to be the one that manages all my affairs in the event that I lose capacity. In the event that, a doctor would say, this person no longer has the ability to manage their own affairs. So both of these are really preventative things to do ahead of time, to just make things easier down the line, especially with both of these documents, but especially with the powers of attorney. The homeowners or the elderly people need to be really careful to watch out for abusive or exploitative heirs or exploitative persons. If they're giving someone the authority to manage financial transactions for them, to potentially be able to sell their house and access their bank accounts and all these things, they need to be sure that it's really someone that they can trust. So at least at our office, when we're executing these documents, we try to use our best judgment to, meet with the person, individually and make sure that they're not being influenced by someone or pushed to, enter into a document that they don't feel comfortable with. And, really make sure that they have someone that they trust doing this for them. Just mentioning, as far as working with mortgage companies, this should be a helpful document to be able to get information from a mortgage company. I know that sometimes the mortgage servicers still tend to give pushback, but really they should. I mean, if someone has become too elderly to know what's going on with their mortgage, and the heir is trying to get information to help them out, and they have a financial power of attorney, the mortgage company really should be releasing the information that's needed to just help figure out the situation. So it would be a really good document for those situations. This here is the flyer that is attached as one of your handouts for today. LAF, if you have clients that are in Cook County, LAF actually has a program that will help anyone over 60 execute these documents for free. We have volunteer attorneys that help staff the program. Generally, the clients do need to be able to get either to our office downtown or to one of our clinics to execute the documents. For the appointments to go over the information so that the attorney can prepare the documents will all be done over the phone. But then the idea is that then they would come downtown or to one of our clinics to, actually review and sign off on the documents, before the witnesses and the notary, like it's required. So this is a special program that we have. We have a special number just for this program that's on the flyer. So definitely, if you have clients that would benefit from this, refer them to this number if they're in Cook County. If they're not in Cook County, I would still try contacting your local legal aid office to see if they could help in, especially if it's a sympathetic situation where you can tell that the homeowner would really benefit from having these documents set up. Okay, so any questions about that? Otherwise, I'm going to move on to actually the next section of transfer of property upon death.
Just give me a second, Katie. I want to make sure. Can you please raise your hand if you will be able to download the handout in the control panel? There are two. One is Adapt Client Flyer with questions, and the other one is the descriptions in the handout. Can you please, guys, raise your hand and let me know? Okay. I think only a few couldn't see the handout. The handout is in your control panel that it says go to webinar control panel, and if you go and look after audio, webcam, polls, you can see handouts, and there are two documents in PDF. Otherwise, I will send it to you with the PowerPoint and the recording of this webinar. Okay? Thank you. Thank you, Katie. There is no other question right now. Oh.
Okay. Okay, sounds good. So the next section is on just the ways that property can transfer on death and what heirs are need to do to make sure that the property is transferred correctly. I know that helping heirs of mortgagors is a widespread difficulty, and I think just understanding the ways that property can transfer can help with that a little bit. So the first type of ownership is called joint tenancy, and to figure out if your client owns their property in joint tenancy, you have to look at what the deed says. The deed has to explicitly say on its face, property is owned by Bob and Mary as joint tenants and not as tenants in common. If it doesn't specify this language or something similar to that language, then it's not held in joint tenancy. Joint tenancy can be really helpful because there's the right of survivorship. So what that means is that if a husband and wife or brother and sister, whatever it is, are joint tenants, there could even be more than two. There could be three siblings, whatever it is, own the property as joint tenants. If one of the joint tenants passes away, then the rest of the property is owned by the other joint tenant. So instead of passing to the heirs of the one joint tenant, it vests automatically in the other joint tenant. So this is a really simple way for property to pass because there's no need for probate. It's not governed by a will. The property becomes owned by the other joint tenant automatically as soon as the other joint tenant has died. So the one thing to look for, though, is that joint tenancy will be severed if one joint tenant conveys their interest without the other person signing off on that. So if Bob and Mary own a property as joint tenants, and then Bob decides that he's going to convey, part of his interest to his brother. So he says, he's going to convey his interest to Bob and Larry as well as Mary. That actually severs the joint tenancy if Mary doesn't sign off on the deed. So then the property is no longer held as joint tenancy, and then if one of the joint tenants passes away, there is no right of survivorship, so property would pass to their heirs instead of to the other joint tenants. So that's just something to look for, is that it is easily severed. Tenancy by the entirety is basically joint tenancy for spouses, but it's only, if they're spouses, it's not automatically held by tenancies by the entirety. The deed, again, has to specify not as tenants in common, but as tenants by the entirety. So it is possible for a husband and a wife to own property as joint tenants that are not tenants by the entirety as well. It depends on what the deed says. Tenancy by the entirety is just like joint tenancy in that there is the right of survivorship. So if husband passes away, wife automatically has full title instead of, it going to husband's separate heirs. The only difference between tenancy by the entirety and joint tenancy is that this gives married couples the additional privilege of the creditors of one spouse can recover against the house if they're only the creditors of one spouse. So if husband had some credit card debt and was sued and a judgment was entered against him, that judgment could not be recorded as a lien against the house if the wife's name was not also on the debt. If they had some joint credit card debt, then that would be a different story. The lien could attach to the house. But if it's only a creditor of one spouse and they're tenants by the entirety, it doesn't become a lien. So apart from that, sort of the default way of ownership is called tenancy in common. If the deed does not say that the owners are joint tenants or tenants by the entirety, then they're tenants in common. This just means, simultaneous ownership of equal interest with no right of survivorship. So let's say a husband and wife own their property as tenants in common. The deed doesn't specify anything else, so then they're tenants in common. Say the husband had some children from a previous marriage. The husband passes away, then what happens is, since there's no right of survivorship, the wife just has her 1/2 interest instead of getting his interest, and then his interest would pass, however it would under Illinois law, which would probably mean that his, children from a prior marriage would have a share, as opposed to the wife, taking over full ownership as with the right of survivorship. So those are the three ways to own property. Here's an example that I gave. I think this is similar to the example that I was just discussing. So just say that husband and wife are joint tenants or tenants by the entirety. Say in this case, husband has 2 sons from a prior marriage, wife has 2 daughters from a prior marriage, husband passes away. Here there's the right of survivorship, so the wife would take full ownership, and the husband's sons unfortunately don't have any share of the property. Whereas if it was the other way, if they held the property as tenants in common, husband has 2 sons from a prior marriage, wife has 2 daughters from a prior marriage, husband passes away. In this case, the wife has 50%, the husband's 50% goes to his heirs. Eventually the wife will pass away, her 50% will go to her heirs. So I guess depending on the situation, depending on, whether there are children from another marriage, the clients may or may not prefer joint tenancy or tenancy in common. It just depends on the situation. Okay, so when we talk about the need for probate or the need for a will, we're really talking to tenancy in common. If there's just joint tenancy or tenancy by the entirety, there's really no need for a will or for probate because property is going to pass automatically to the other joint tenant or to the spouse. So if there's tenancy in common, there may be the need for a will. Okay, so the first thing to ask if there's not a joint tenant here is whether there is a will. If there's a will, property is going to pass as the will designates. If there's not a will, what's called the laws of intestacy are what define how the property is going to pass. So intestacy is in Illinois law. If you want to see exactly what it says, you can Google this statute and it'll come up. But essentially, the general rule is that if there's no will, the property is going to go 50% to the spouse and 50% to the children. If there's no spouse, then the property is going to pass 100% to the children. If there's a spouse but no children, then the property is going to pass 100% to the spouse. If there's no spouse or no children, this is where you'd probably want to Google the statute if you were really interested in seeing how the property passes. But generally it goes to the parents and to the siblings in equal parts. If there's only one surviving parent, that parent's going to get a double portion. and if the person who passed away had 3 siblings and one of the siblings had already passed away or had predeceased this person, then that sibling share would go to their children. So again, it's really a case-by-case situation, but there's a statute here that you can Google it if you really want to see exactly how property is going to pass. Okay, so just I have a couple hypotheticals to help understand some of these concepts. So if Wendy and Tom are joint tenants and they're married, they have 3 adult children. So if Wendy passes away, what is their children's share? I'll give you each a minute to think about that. Uh-oh. For some reason, the words are not coming down the way that they're supposed to. So in this case, their children's share would be nothing because they're joint tenants. Upon Wendy's passing, Tom is a surviving joint tenant, so he's going to take full ownership of the property. So their children are not going to have any interest at this point. Okay. So hypothetical number 2 is if Wendy and Tom are married with 3 children, they're both on the title, but this time the deed doesn't say whether they're joint tenants or tenants by the entirety, and Wendy passes away. So in this case, what share do the children have?
Sorry, Katie. I have here a comment. If you could repeat the first hypothetical sample.
They want to repeat the first hypothetical? Sure.
Yeah, please. Thank you.
Sure, yes. I don't know why the answer wasn't coming up. Okay, so imagine that Wendy and Tom are joint tenants of their home. So they're married, they're joint tenants, and they have 3 adult children. If Wendy passes away, the question is, what is the children's share? And so this is actually kind of a trick question because when Wendy passes away, the children do not yet have a share, and that's because they were joint tenants. And so as a joint tenant, Tom had the right of survivorship, which means that when Wendy passed away, Tom became the sole owner of the property. So as Wendy and Tom's children, the children probably will one day, be the heirs of Tom, presumably, but at this point, they don't have any share in the property because Tom is a surviving joint tenant, and so he still has full ownership of the property. Does that make sense? Any questions about that?
No, if people wanted to answer about the questions, you can, about the hypothetical scenarios, you can write your answer in the question box. And okay. I don't know if this one, the answers that I have now is applicable to the hypothetical number 1. And somebody just wrote 50%, and another one says 50% goes to children, and another one says 0. So what is the answer about this one, Katie? Okay,
so for hypothetical number 1, the answer is 0. The children have 0 share because Tom has 100% as a surviving joint tenant. Okay.
Okay, great. That's resolved answer 1, hypothetical 1. So let's go with hypothetical 2.
Okay. So people want to write in their answer for hypothetical 2. This is similar. And still Wendy and Tom are married with 3 children. Wendy and Tom are on title to their home. But in this case, the deed doesn't say whether they're joint tenants or tenants by the entirety. So the question is, in this case, if Wendy passes away, what share do her children have? Do we have any answers for that?
So write your answers here in the question box to see. Okay, here I can see. So somebody says no, 0. When is determined when purchasing a home whether to be joint tenants? This is like a question, it's not the answer. So I have how or when is determined when purchasing a home whether to be joint tenants, tenants in entirely, etc.
Oh, it's at the time of purchase of the home. It should be, because that's when the deed is signed, and so it's whether the home is owned in joint tenancy or by tenancy by the entirety or tenancy in common depends on what the deed says. So the decision is made at the time of the purchase of the home. However, the owners could change their mind later and execute another deed, but they would have to execute another deed to change that. If they owned it as tenancy in common and then they decided they want to be joint tenants, they could change it, but they would have to execute another deed.
Okay, I have another answer here. It says 25% divided by 3 is the answer in question number 2. Somebody says 50%. What do you think about 25% divided by 3?
I believe that is correct. So that person, I think, is understanding well this concept. I think that is 25 divided by 3 is 8.33. So the way that you come to that is, here the deed does not specify if it's joint tenancy or tenancy by the entirety. So if it doesn't say one of those terms, it's the property is owned in tenancy in common. That's the default ownership. And tenancy in common basically means that we have two different 50% owners. They each both have their own 50% interest. And there's no right of survivorship. So with tenancy in common, since there's no right of survivorship, when one person dies, when Wendy dies, her 50% goes to her heirs. And Tom still has his 50%. So regardless of whether they're married or not, that's what's going to happen. So in this case, they each had 50%. Wendy passed away. So Wendy's 50% goes to her heirs. So if you go back to intestacy, we're assuming that intestacy happens here because the question at least doesn't tell us that there's a will. So under the laws of intestacy, the general rule is 50% to your husband, 50% to your children. So Wendy already had 50%. So her 50% of her half of her 50% goes to her husband. So even though Tom already owns 50% of the house, now he gets half of Wendy's share as well. So Tom is a 75% owner of the house. The remaining 25%, or half of Wendy's ownership, goes to her children. So here she has 3 children, so each child gets a third of the 25%, or 8% of the house. So her 3 children each have 8%, and Tom has 75%, if that makes sense. As long as that made sense at least to one person, so that's good. Do you have any other questions about that?
No, I think now they get it. It says like a Tom gets half, and the 3 kids divided 50%. And only says only the amount of Wendy's shares divided by 3, so by the 3 children. So that's what they are answering right now. And I'm telling you, I just want to mention, minutes ago, I sent you by email the handouts only because there were people that weren't able to download from the control panel. I will send the PowerPoint slides with the recording of this webinar after we finish the webinar. And in that way, I will send you the recording, okay? So please be patient and pay attention. This is very interesting. Thank you, Katie.
All right, thank you. Okay, so I have one other hypothetical. Going back again to Wendy and Tom. So here I'm saying they're married. They're on title, this time as joint tenants. The deed specifies that they're joint tenants. They have 3 children. However, without Tom knowing, Wendy decides to go and add her sister on title. So Wendy kind of goes rogue and goes on her own and signs a deed saying that she's transferring the property to Wendy, Tom, and her sister as joint tenants. So Wendy probably doesn't know the law as well, and she's assuming that what she's done is just add her sister so that she, Tom, and her sister are joint owners. But unfortunately, that's not what happens. So then Wendy passes away. What share does that leave Tom with? Does anyone have an answer to that? I know these are getting trickier.
Okay, let's wait a minute and see if people can read it.
See if anyone wants
what is the question and what are the answers? Use 1 minute. Okay. So I'm starting having answers right away. So people say between 50%, 50% now in common, and another one say 75%, and another one 25%. So there are a lot of mix.
Okay, so the question is, what
has 75%, and another one says 33%. So there are a lot of divided answers.
Okay, so we're a little bit divided. So Tom has, we'll say more than 50, but less than 75. So let's go through that. So the first point here is that Wendy severed the joint tenancy when she added her sister. So one of the rules of joint tenants is that, if two people are going to own the property as joint tenants, they have to be acting unilaterally. They have to act together. So if Wendy and Tom own the property as joint tenants, and then Wendy decides to go sign a deed and add her sister, since Tom wasn't a part of that, Wendy actually severed the joint tenancy, whether she knew it or not. So what Wendy did is, as soon as she had executed and recorded that deed, she got rid of the joint tenancy and turned this into tenancy in common. So Wendy and Tom each had a 50%, that means that Wendy and Tom each have a 50%, had a 50% share. So Tom still has his 50% share. That hasn't changed because he didn't sign any deed. He didn't change anything. Wendy, what she did was sign her 50% share to Wendy, Tom, and sister. So Tom basically has his one half, plus he has a third of Wendy's one half, which is like a sixth. So Tom has a half plus a sixth, if that makes sense. Tom has he keeps his one half. He also gets a third of what Wendy had transferred. And then plus also what he inherits from Wendy, which makes it even messier. So then when Wendy passes away, her tiny share, which is a third of a half, passes to her heirs. Tom is her husband, so he gets half of that. So the math behind all that comes out to 9/12. But really the takeaway here is that if you see a quitclaim deed that's not signed by both joint tenants, there's no longer a joint tenancy. So you have to recognize that it has changed into a tenancy in common. So even if, here Wendy had the languages of, as joint tenants on the deed, but she had already severed the previous joint tenancy by adding Tom. So it's really the important point here is to watch for something like that. Do you have any questions about that?
So Katie, when you say that is like Tom has the more than 50% but less than 75%, it means that Tom has 66.6%?
I'm sorry, I don't have the math. So the math is pretty messy here. I don't think it's exactly 56. And I'm sorry, I don't have the actual percentage here. The point more is not the percentage as much as the fact that the joint tenancy is severed. So he gets to keep his 50%. He has that, but he also gets what Wendy has given to him, which she gave him a third, which is really a sixth, since she only had half. And then when she passes away, then he inherits whatever share there is too.
I have another question here. Can joint tenancy be held by more than two people, not necessarily spouses?
Yes, they do not need to be spouses. So tenancy by the entirety is only an option for spouses. And again, it's not automatic that if they're spouses, it's tenancy by the entirety. There has to be that language. But yes, joint tenancy can be held by brother and sister, even by stepbrother and stepsister. It can be held by really any combination, as long as there's that language that it's held in joint tenancy. It can even be three people. I mean, it could be three siblings.
Okay, and I have a mix questions here regarding the 9/12 that you put here at the end when Tom has half plus 1/6, 1/3, etc. So you say that the answer is 9/12. So the 9/12 is a 3/4 of the property.
Yeah, I'm sorry. I'm hoping that I did the math there because I was really focused on the math as I was on the concepts. But I think that that's right, because so Wendy's half is already divided in thirds. So yes, I do think that that's right. That once Wendy passes away, he has 3/4 of the property. Her sister has 1/6, and then Wendy's other heirs, which would be the children, have divided the other 1/6. Is that right? Yes.
That's great. Our counselors always, they are on top of mathematics, and that's why they are just making with all of them. Yeah, it's basically the 3/4 of the home is just property. Thank you, guys. Thank you, Kate.
Okay. Yeah, thank you. Okay. Okay, so getting into the need for probate. So I hope that understanding the difference between tenancy in common and joint tenancy, tenancy in the entirety, helps understand when probate is and is not necessary. Again, if the deed is held in joint tenancy or tenancy by the entirety, you shouldn't need to file probate, at least not yet, unless the tenancy has somehow been severed. So if you have a wife come in and her husband has passed away and she's worried about whether she's entitled to the house, if the deed says that they're held in, that they held the property as joint tenants or as tenants by the entirety, and they neither of them had ever executed another deed to sever that joint tenancy, the wife is the sole owner of the property and there's no need for probate. I think that even mortgage servicers tend to forget that sometimes, or not be as aware of it, and they'll ask you for probate, sort of prematurely without realizing that, in cases of joint tenancy by entirety, it's not needed. But it is necessary where there's tenancy in common, or, say the wife was a surviving joint tenant, now the wife is passing away, and it needs to pass, the property needs to pass to her children. Whatever the case is, there's definitely times that probate is necessary. It's necessary whether there's a will or whether the property is passing by intestacy. Some people think that because there's a will, there's no need for probate, but the will does unfortunately have to be probated as well. A trust is one way to avoid probate, but again, that's a separate issue. That's where the recorder of deeds will show that the property was transferred into a trust, and that trust is confidential, but the clients would have a copy of the trust to show how property is held. So probate is, I'm sure you're somewhat aware, it is a time-consuming process, and it's not immediate. It's going to take some time to go to court and get the proper documents to allow to show that title is passed the way that it should. So that's again why I'm going to push again that the TODIs, the transfer of death instruments, are really great instruments to avoid the need for probate. To allow someone to just say, hey, when I pass away, I want property to pass to my son, and that saves the son the hassle of having to go to court, and the time of having to go to court and sort all that out later. But as far as when, too often it seems there is a need for probate, and working with the mortgage servicers, they'll, ask you for proof of the probate case. What they're really looking for is a document called letters of office. So even though the probate case can take a long time to sort out, the letters of office should be available about a month or so, maybe 45 days after the case is filed. So the way probate cases work, again, there's two kinds of probate cases. There's probate with a will or probate without a will. So if there's probate with a will, the actual original will has to get filed with the probate court. Along with that, or else right after that, the client or their attorney would file a petition asking to probate the will. 30 days notice has to be sent of that petition, to anyone else who has an interest in the property or who, could potentially be an heir. And then at that point, the client goes to court and can get appointed to be the executor of the estate. And they're given letters of office, which basically says, you're the executor of the estate. You're the one, managing the estate. This is a document that the mortgage servicers tend to need as far as a loan modification application or something like that. So they don't necessarily need the whole case to be resolved just to consider the application. This document is usually what they're looking for. So then once that happens, then notice to all the heirs or legatees, who are beneficiaries under a will, they need to get notice of this appointment so that they have the opportunity to come in and object if they don't agree with it. There's a special rule where notice has to be published to creditors if it's been less than 2 years since the death, so that if there's any creditors, they have the right to come in and say, hey, I should get paid from this estate. This person owed me money. And then whenever all that has passed, there's a document that's called the release of the estate's interest, and it's not a deed. The reason that it's not a deed is because actually, property really passed when the person died. A deed conveys property itself. Here, a deed is not necessary because as soon as the person passed away, property passed according to the will. It's just that you have to go through this process to prove that, to establish that. So the release of the estate's interest is eventually executed and recorded with the recorder of deeds that says, okay, this person owned the house, they passed away, under their will, their son or their son and daughter, all three of their children, whatever it is, now own the house. And then that gets recorded with the recorder of deeds. So that process can take a while, even though title vested at death. So that's what's confusing. As far as working with mortgage servicers, is they want to see something right away. I mean, if the person passes away and, maybe they fell behind on their mortgage, right around the time of their death or in the months leading up to their death or something like that, the mortgage servicers will want to see, okay, well, where's the proof of the probate? Show me how the title passed. And the thing is, even though title passes immediately upon their death, it takes a while to go through the process to actually get the documents to prove that.
Katie, before you move forward, I have a question here. It says, if wife wasn't entitled and having Illinois as a marital estate, what happens on the death on the spouse in this title?
That's actually what this slide is talking about is if she's a wife, but she wasn't on title, and if there wasn't a will, then the property passes by intestacy, which gives, in Illinois, that gives spouses a 50% interest. If there's a will, maybe that gave her 100% interest, but if she was not on title, then she has to file probate. So yeah, again, that's why joint tenancy is a really good tool to avoid the need for probate. A transfer on death instrument, I mean, if the husband had executed that before his passing and said, I'm the sole owner of this property, but upon my death it should go to my wife, that would have saved the wife, the hassle of going through probate now, but she would have to go through probate now, it sounds like. Any other questions?
Thank you. Yes. Can the home be sold by the executor if there is no mortgage and the home is in probate?
Can it be sold by who?
By the executor. If there is no mortgage and the home is in probate.
Yes, I think it could, but I think that before the court's going to allow the executor to sell the house, they're probably going to require the probate process to, go through its completion. The court's definitely going to make sure that, any other heirs or any other, potential heirs are notified of the probate case and have an opportunity to come into court and object, before that person is allowed to sell the house. But at the completion of probate, yes, he could be allowed to sell the house.
And can you add a spouse to a deed? How you can add it?
If you're still living and of sound minds, you absolutely can still add your spouse to a deed. You can do what's called a quitclaim deed, which is a deed that's not done, for any consideration, not done because you're selling the house, but just because you want to add someone. But yeah, you can definitely do that and add your spouse. It's probably a good idea to do that with an attorney, but it's possible to even do that without an attorney. The deed has to be recorded, so you have to execute the deed before a notary and then go to the recorder of deeds office and record the deed. But you can absolutely do that, and it's a good idea to do that if you want to make sure that your property passes to your spouse.
Okay. Thank you, Katie. That's it.
Okay. So again, just briefly, the process of probating without a will, it's a different kind of probate proceeding, but it's similar. So here you don't have a will to file with the court, so you just file a petition for probate. Again, you have to mail notice to all the heirs or potential heirs. And then you also get the same document, letters of office. Here you're getting appointed the independent administrator of the estate instead of the executor of the estate. But it's a very similar document. It's called the letters of office. And again, that's what the banks seem to really look for as far as getting looking at an application for a loan modification or an assumption. Once you have that document, again, you have to send notice to all the heirs, give everybody a chance to come into court and object if they have any problem with it. If it's been less than 2 years, you have to publish notice to any creditors. And then again, if no one comes in and objects, there's no issues, then you get the court's permission to close out the case, and you record the release of the estate's interest to this time show that property passed, however the laws of intestacy would have it pass. So it's a similar process in both situations. It takes about the same amount of time in both situations. It can take longer, of course, if someone objects or if somebody causes a problem.
When you talk, I'm sorry, but when you talk about the deeds and the quick claim, so if the spouse has purchased a home and eventually does a quick claim deed for the spouse, and he has 2 children, when he passes, how the home will be distributed?
Okay, so he owns a house and then he does a quick claim deed, to his spouse or to the children?
No, for the spouse. He did a quick claim for the spouse, but he has 2 children. So what happened with the property if he passed?
Well,
so
again, it
depends
on
the quick claim.
Yeah. Well, it depends on whether the quick claim says that it's joint tenancy or tenancy by the entirety, or if it's just the default of tenancy in common. That's where that comes into play. If a situation that you might see is if say a man is widowed or something, and he has children of his own, and then he goes and remarries someone else, and he decides to add her to title. If he adds her as a joint tenant or as a tenant by the entirety, and then he passes away, it basically cuts out his children, because she has, as a joint tenant or as a tenant by the entirety, the wife would have the right of survivorship, and she would take full title to his house automatically. So, it is possible that would happen. It's also possible that he would add, his new wife as a tenant in common. Then if he passes away, his 50% interest passes to his heirs, which would be half to the wife, half to the kids. That way his kids would not be cut out of it. But if he added her as a joint tenant or tenant by the entirety, he basically would have effectively cut his kids out. Does that answer the question?
Yes, and I think the most important here is remember that this is informational only. You should refer your client to a LAS, for instance, or assist legal aid, because we cannot resolve that type of issues. This is very important that only attorneys need to see those documents and giving the best advice. Okay.
Yeah, exactly. I'm hoping that having an understanding of these concepts can just can help you. But obviously, with a case by case situation, if you're seeing a really messy situation and you're concerned about someone's home ownership, or them at risk of losing their home ownership, please refer them to LAF or whatever your local legal aid office is. Okay. Okay, so going back to the probate, the process, there's this kind of magic document called the letters of office that the court is going to give. There is a statute that kind of sets out who should get the letters of office. Again, this can be kind of a messy situation, especially, maybe where there's a marriage later in life or something like that. There might be a child who really feels that they should be the one dealing with dad's estate and getting the letters of office. But the statute kind of says that the surviving spouse should be presumed to be the first one. So anyway, that I just have this statute here just to show that there is something that sets out the order for, who should be presumed to get the letters of office. Although, the surviving spouse can also always agree to, whatever they want to agree to as well. Okay, so kind of a messy situation is, you might have, I would imagine that you might have clients come in that are heirs to a property, but they're not the only one. I know that we see that situation a lot. Sometimes there were, maybe two or more kids, and one kid is really the one that, had moved in and was taking care of mom or dad, and, now is the one that's paying for the property and cares about keeping the property. Maybe the brother and sister live out of state, are not as involved, or whatever the case may be, but they're still heirs. Or maybe there was a will that left it to all three of them regardless. So what do you do in that situation? So the easiest resolution is if the uninvolved heirs are willing to just sign a quitclaim deed, releasing their interest, or giving their interest to your client, or the heir that cares about the house, the heir that's doing the work and spending the money to keep up the house. If they're willing to just sign a simple quitclaim deed, this can solve that problem. Sometimes the conversations that we have to have, revolve around, well, if you're not willing to sign a quitclaim deed, are you willing to take on the responsibility for it? Because it's not just a free house, right? There's responsibility. There could be a mortgage. There's taxes. There's things like that. So, maybe they need to have a conversation, about, if they really want, a share of the house, are they willing to help with those expenses? And very often when they understand the expenses, that are involved, they're more willing to just relinquish, and deed over their interest. So when in the context of, applying for loan modifications, which I know you guys probably see a lot and we see a lot, the other heirs have to be willing to sign the application for loan modification and to co-sign the loan modification if they're not willing to get off title. So it's sort of one of the two. They either have to sign a deed getting themselves off title, giving up the property, or if they're going to if they're really going to pursue their interest in the property, they have to be willing to sign the loan modification and possibly even provide whatever income documentation is requested to get the loan modification. Okay, so just kind of a recap of the ways that property can be transferred. Again, I'm going to push again for the toady. If your clients, go through the simple process of executing a transfer and death instrument, when they pass away, their property transfers automatically to whoever they designated on that toady. It's very straightforward. It's very simple. A document can be recorded with the recorder of deeds just to clarify that they have passed away and that property has transferred. So that's really a straightforward process. Joint tenancy and tenancy by the entirety, as long as it wasn't severed by one of the tenants, one of the owners, unilaterally transferring their interest to someone. That also is an automatic transfer upon death. So if husband and wife or brother and sister own it as joint tenancy, one of them passes away, the other one automatically is the full owner of the property. Trusts are another way that, probate's not necessary because the property is deeded into trust, and the trust says, who owns the property. And again, with trust in the context of loan modifications, it does seem like they, to record the loan modification, they have to have the property removed from trust. So that is just sort of an extra barrier to have to deal with there. But if there's not one of these three things, if there's not a toady, it's not joint tenancy or tenancy by the entirety, and there's no trust, then you're going to need probate at the time of someone's death. Whether there's a will or not, probate is going to be needed. Okay, so the last section that I have here is just on, it looks like I only have a few minutes left, but just on some protections for heirs. So I'm just going to go right into this quickly. I think that you're all aware of the term of assuming the mortgage. The thing to be careful here is that if one of the heirs agrees to assume the mortgage, they are taking on the personal liability for the mortgage also. If you see a case where the mortgage stayed in the deceased person's name, and the heir is the son or daughter has just sort of taken on responsibility for paying that mortgage and hasn't defaulted on it, there's nothing wrong with that. And it actually kind of protects the son or the daughter because they don't have any personal liability on the mortgage. But if there's a default, that's where, the servicer is going to not want to provide any information anymore. And that's where potentially the heir is going to have to consider applying for an assumption of the mortgage, along with a loan modification to, put the mortgage in their name. So the general rule is that with contracts in general, you should be allowed to assume a contract, assume somebody else's contract. But there's some different rules for mortgages because obviously mortgage lenders want to see creditworthiness. They want to see that, if you're just going to assign your mortgage to somebody else, they want to make sure that that person actually has a job or has income and can pay the mortgage. They're not going to be okay with you just, transferring it to anyone. And so to protect mortgage lenders, there's something called a due on sale clause that allows the mortgage company to accelerate the mortgage and demand payment in full if the property is transferred. So that means if you own your house and you have a mortgage on it and you just decide that you're going to give your house to your friend, and the friend's going to pay the mortgage, when you transfer your house to the friend, the mortgage company has the right to say, no, I don't agree with that. I want you to pay off the mortgage right now. So they generally, have that right. But Garn St. Germain was a federal law that went into effect that, among other things, limits the situations where a lender can exercise the due on sale clause. So it also, parts of Garn St. Germain protect lenders by allowing those due on sale clauses. But there's these 4 categories where lenders cannot exercise the due on sale clauses. So if the property is transferred upon death to a joint tenant or to a tenant by entirety, or just transferred to a relative upon the death of the borrower, or if the property is transferred to a spouse or child, which is not necessarily even upon death, but just to a spouse or child, or transferred as part of a divorce. In these cases, those transfers basically the mortgage company should respect them and should allow them and should not, accelerate the mortgage or claim that the mortgage has to be paid in full. So in effect, if the property is transferred by one of those 4 categories, the mortgage company should allow an assumption. And the reasoning behind that is just, to not allow an assumption in those circumstances would just be unfair. So the CFPB recently strengthened its rules to, kind of based on Garn St. Germain. Originally, back in 2014, the CFPB, had put in federal regulations that basically just said that, since an heir has already acquired title to the home, since they acquire title, by will or by intestacy, they acquire title upon the death of the borrower. That's not really a transfer that triggers the ability to repay requirements. That just says that the mortgage company doesn't have to consider their ability to repay, that they should, be able to allow them to assume without having to look at their ability to repay. So that sort of allowed the mortgage company to allow assumptions, but it doesn't really give the mortgage company any duties to allow assumptions if the mortgage company doesn't want to. But in 2018, the rules got a lot stronger. And the actual definitions under some important federal regulations, the definitions for borrower and consumer both now include confirmed successor and interest, which is, again, based on those same 4 categories of Garn St. Germain. So what that means is that those heirs, if it's, it falls within one of those 4 categories, should have essentially the same rights that the original borrower did. They should have the rights to do a request for information under RESPA, which is like a formal request for information on the loan. If they need, a copy of the loan modification, or they need to know the interest rate, or the amount of defaults, or when the loan went into default, they should be able to get all that information if they fall within one of those categories of heirs. They also should be able to benefit from the loss mitigation rules under RESPA, which are, the federal rules that say if you apply for a loan modification, you deserve to be reviewed within 30 days. If you're denied, you deserve the right to an appeal. You need the right, a denial letter that explains why you're denied, things like that, all those protections, including the protections that, if you apply for a loan modification while you're in foreclosure, they can't move forward with the foreclosure sale as long as you apply, by a certain point. The heirs within those categories of Garn St. Germain should have all those protections now. And then again, these sites just show that that Freddie Mac and Fannie Mae and the FHA, the rules on FHA loans have also honored, not just honored Garn St. Germain, but amended their own guidelines to, to show that they're requiring the same, that servicers respect the borrowers and the heirs of borrowers in those same four categories. So the takeaway here is really, and I know that the definitions handout that was given, I put those same four categories of Garn St. Germain. Really what I want you guys to be able to take away is to be aware of those four categories. If you're seeing people that fall within those categories, they should have the right to assume the mortgage if they choose to do so. But they are going to have to be proactive to actually take the steps that are necessary to get on title, and that might involve filing, a probate case, depending on the situation. So yeah, that's sort of the takeaway. And then just on reverse mortgage borrowers, you may be aware of these rules, but the two things to be aware of is that, the surviving spouse generally should be allowed to remain in the home for their lifetime. And in cases where you're seeing heirs of reverse mortgage borrowers, if they have the resources to come up with the value of the home, even if it's less than the balance of the mortgage, they should be given the option to pay for the house by paying the value of the home. And those are definitely cases where you should refer to legal aid, to LAF or to your local legal aid, if you're seeing people in these categories, being denied the opportunities to keep their homes. So here I just have sort of a recap. The first step, if you have an heir come in the door, someone who's inherited property by whatever nature, look at the deed and see. If they're already a joint tenant or tenant by the entirety, and that tenancy hasn't been severed, they are already the owner of the property. They shouldn't need anything further. If they're not already on the deed, look and see if there's a TODI, a transfer on death instrument. You should be able to see that by looking at the recorder of deeds, because it should have been recorded. So if there's no TODI and it's not joint tenancy or tenancy by the entirety, that's where probate is going to be necessary. You can send them to the Daily Center for help. You can send them to legal aid for help. The main thing that they're going to need to do is gather the names and addresses of anyone who's even potentially an heir, any other family members. So then they can start the process of applying for a loan modification and an assumption. If the loan has gone into default, they should be able to apply for both of these simultaneously. If probate was necessary, they're going to need those letters of office. And like I said, that's going to take 30 to 45 days. And ideally, they would get deeds from other heirs if there's other heirs as well to show that they're the one taking responsibility for the property. Or the question to ask if you're seeing a reverse mortgage, if it's not a surviving spouse, if you can get a sense of whether the person might have the funds to come up with the value of the home, that definitely refer them to legal aid in that situation, because they should have protections there as well. So I think that's essentially all that I have. I just had sort of this additional note at the end. So I know that this whole presentation has been on, deceased borrowers, but it's just important to remember that a lot of these same protections go into place for divorced or divorced spouses as well. So I'm happy to answer any other questions. Otherwise, feel free to reach out to me directly as well. My information is right here.
Thank you, Katie. I have one more question. It says, will an affidavit and death of heirship work instead of probate?
Not in Cook County. In Cook County years ago, I think we were able to get away with that. And then Cook County sort of changed their processes at the recorder of deeds. They don't even allow you to record an affidavit of heirship anymore without filing probate. I'm not sure how it works in the other counties.
So yeah,
but I think that probate is generally a better process. Yeah.
Yeah, here in Cook County now, so the counties works different and they have different rules. So they have to check in your local county. Okay.
Yeah.
Yep, I don't think so. I have any other questions at the moment. So thank you so much, Katie. Thank you so much, LAS, for providing those webinars. Thank you, everybody, for joining us. I will send you the recording with the PowerPoint. And, of course, if you have any questions, you have the information, Katie, Liz, and then Lindsay as well at LAF. Thank you so much and have a good afternoon. Thank you, Katie.
Thank you.
Okay, bye-bye.
Bye.